listen to my questions, and then answer truthfully, okay?
Yes.
All right. Mr. Sledge, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes.
Initialed the factual acknowledgments within the document, correct?
Yes.
All right. Let me ask you one question before I get there, though. What day were you arrested on this case?
I want to say May 27, 2022.
May 27th, 2022. Well, that works out well for my limited math here. Okay. So May 27th of 2022 to December 28th of 2022. That seems to me 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th of 2022, when you initialed those documents, you had been locked up for 7 months.
Yes.
Just like Jontavia
You
Stevens.
had previously moved for a bond in this case, correct?
Yes.
You moved for a bond on October 13th, I believe, 2022?
I don't remember the date, but yes, I know.
It was in October?
Yes.
And the state opposed your release on bond, correct?
Yes.
And Judge Glanville denied bond, correct?
Yes.
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Objection, answer, and compound.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Sustained.
Let me ask you, when you were locked up, we're saying locked up, where were you living? Where were you held?
R-I-C-E.
At the Fords County Rice Street.
Okay, that's Fulton County Jail.
Yeah, jail.
Okay, and we're not, generally speaking, is that a nice place to be?
Objection, roll.
Overruled. Thank
No.
God.
Is that a dangerous place?
Yes.
Is that a filthy place?
Yes.
Okay. On December 28th, 2022, there were some things going on in your life, correct?
Yes.
Okay, you've already shared with us that your mother was ill.
Yes.
Certainly, on that date, you wanted to get home to your ill mother. Isn't that correct?
Yes.
You are also a father, right, Mr. Sledge?
Yes.
You have 8 children, is that correct?
Yes.
Okay. On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23, the youngest is 9.
The youngest was 9.
He 9 now.
Okay, so about 7.
Yeah, about 7 then.
All right. And do your children live in Atlanta?
Yes, all of them.
Okay. Do you spend time with your children?
Yes.
Objection, relevant.
Sustained. Showed the picture with
Do
his
you
kid, though.
attend to your children's daily needs?
Objection, relevant.
Sustained.
Your Honor, may I be heard?
You may.
It goes to his need to get out of jail.
Yes.
All right, well, get to it.
Okay. Do you attend to your children's daily needs?
Yes.
Do you drive your children to school?
Objection, Your Honor, relevance.
Let's move along a little bit.
Okay. Did you have a significant other at the time?
Yes.
Objection, relevance.
Overruled.
Yes.
And I don't even need to say her name. Her initials are DB.
Yes.
Okay. On December 28th, 2022, did you miss DB?
Yes.
Did you miss your children?
Yes.
You indicated that Derek Wright is your attorney,
Yes.
and he's represented you in the past,
Yes.
and you hired him on this case.
Yes.
Okay. When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount.
Objection, relevance.
He's testified that he did not, his understanding was he did not pay his attorney. You didn't, the money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
Yes.
That was your understanding.
Yes.
That was his understanding.
Yes.
You did not have a an attorney to take this case to trial.
All right, no, now that we all know that that's not true, that anybody who can't afford an attorney is entitled to get an
Well, I'm
attorney
gonna get
without
there.
cost to them.
I'm going to get there. There were people in this case that couldn't afford an attorney, correct?
Objection, Your Honor, speculation, relevance.
People were,
Your Honor,
people.
No,
still
they've
don't
had-
have
Hang on,
attorneys.
hang on.
They've
Don't
had
talk
hearings
over
about
each
it.
other. That is not relevant to the question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes,
If he knows he's going to
you
sit.
may, yes. You know what?
They're going
Let's
to do
break
lunch.
for lunch, because I know that this is going to take more than 30 minutes for you to do your cross. So let's
Holy.
just break for lunch right now.
I get why ordinarily that wouldn't be relevant, but they have had actual hearings about attorneys not being able to
Uh-huh.
survive the duration of this trial with what they were
Oh,
getting
right.
paid, even public
Well,
defenders.
I've got some, we have to deal with some other matters. Let's say 1:30.
And I think the Rule 22 might be during lunch too. So during lunch, we'll get caught up on super chats, you guys. I also want to give a shout out to the Black Law student. We're going to look at a letter that he proposed to write to Judge Whitaker and make sure we don't miss any of these arguments that I'm sure the attorneys need to be present for while the jury's on lunch. Thank you so much to Queen Tara, who says, thanks for your diligence. Love your stream. Thank you so much for being here. Bees on Mars says, last minute love is like raisins in potato salad. Somebody brought, but nobody
Let's
wants.
take up this objection.
So, Your Honor, and I say this not in a pointed fashion. You weren't here in the beginning of this case.
Yeah.
And I know that you're not presiding on the case with the other individuals. The reality is, people were severed off this case because our public defender system
Yes.
did not provide people attorneys. People were sitting in jail for up to 2 years. I'm not
Yes.
even sure everyone has an attorney to this date. These gentlemen that are not sitting here, that are sitting in 901 Rice Street 2 years later, I don't even know if they have attorneys now, but I do know when we started this trial, people were severed because the public defender's system had not provided attorneys. Mr. Sledge knew that. Mr. Sledge, and this is the reality, and I don't think we should hide it from the jurors. The reality is Mr. Sledge had two options: plead guilty or wait for an appointed attorney to try this case, and he would have been sitting in jail, and he'd still be in jail today.
All right, all of those cases are ready to be tried right now. Everybody who's been severed out other than for that reason is ready.
We're approaching 2
Okay,
years.
Well,
I
right,
mean-
and they're still in jail. And
Well,
and
so are
that's-
all of these defendants.
Well,
But we're
I-
not going to get into that, are we?
well,
3 years. 4
at this point,
years.
I really probably wouldn't mind, but I'm not going to speak for everyone else. But it goes to his mind state. He had two options: either take this plea or end up in the same bucket that Demekion Garlington and Demise McMullen and other people were in, which was be unrepresented, sit in Rice Street until the state gets about. So when we say we know people are appointed attorneys, yes, I know theoretically under the Supreme Court precedents and under our Constitution, appointed indigent individuals are supposed to be appointed attorneys, but in reality, that did not happen here.
That may not have happened immediately, but
It
it
didn't
has
happen.
happened. And
It didn't happen until very recently.
I mean,
Your Honor.
that does not need to be what is I mean, there are so many collateral issues in this case. So if you want to ask him much more pointedly what his understanding was, but we don't need to go through every co-defendant who may or may not have had. an
Oh, I
attorney.
wasn't going to do
You seem
that.
to be going down
No,
that
I was
road.
just asking if he knew. I was saying he was aware that attorneys were not being appointed to represent the other people he was with, and he didn't want to be in that situation. And Miss Love was objecting, and I never got a chance to get to
Well,
it.
I mean, for all I know, Ms. Love's now going to want to cross-examine him on his actual financial affairs, which I think would be fair because I'm not sure,
don't have a
that
problem with
wouldn't be fodder for redirect at this point.
I mean, I don't really have a problem with her cross-examining him at this financial affairs. Mr. Wright might.
Well, I mean, why don't you propose a couple of questions that you think will get to the heart of the matter?
Well, I've already established that he didn't hire Mr. Wright to try the case. He was aware that other people that had been arrested that could not afford attorneys were unrepresented, remained unrepresented 7 months later. And he didn't want to be in a situation where he was sitting in 901 Rice Street without an attorney to represent him.
You are not going to be able to ask him about well, I see what you mean. Okay, well, let's not give it the impression that it's indefinite and still going on right now, because we all know that's not accurate.
Well,
That's not accurate. I can pull up all 19 of the co-defendants, I
Well,
guess, and look and
all
see,
represented.
but
and
they're
we-
all represented. They have
all-
been for quite a while,
Yes,
right?
ma'am.
a few
Gone to
months.
several hearings with them and their attorneys.
They're at like final plea stage, aren't
Oh.
they?
Yes,
At
they're
the-
actually.
2
pushing
years later.
trial in the middle of this
Except
trial.
that, yes, which needs to happen, but that's a whole other issue. Okay, so you get about one more question on that and then
I
move
propose
on.
two.
Okay, what are the two?
That he was aware that on December 28th, 2022, there were people on this case that could not afford attorneys. They had not been appointed attorneys by that date, and he didn't want to be in their situation. I guess that's three, if we're not going to make compound.
May I respond?
You may.
Judge, I would object to Mr. Schart's assertion, number one, that he's established that Mr. Sledge did not have the ability to secure Mr. Wright for trial.
So he said on direct that he didn't. He said, I couldn't afford Mr. Wright for trial, and that's why I pled.
Okay, we'll get into that. Also, I object to the speculation regarding, his question regarding whether or not anyone else could afford or had an attorney or would be appointed an attorney or might have to wait for an attorney.
I wasn't asking for
It's not-
speculation. I said on December 28th, you
What-
knew that other people didn't have attorneys yet. We were all in court.
I
We were all
mean-
in court. We were all talking about it openly in court.
Yeah.
There were people there that did not have attorneys.
Yes.
Yeah.
They all sat right there and looked sad, and we all
Okay,
openly
yes, Ms.
discussed
Love.
it.
Thank you.
I mean, that is
It is
true,
an
right?
improper-
That on December 28th of 2022, there were at least some co-defendants without an attorney
Yes.
yet, because there are so many conflicts.
There were
Okay.
still. on
Listen to her
December
tone of voice.
29th. We
There
would
were.
object that Mr. Schart's line of questioning is an improper attempt to elicit sympathy from the jury. He has already asked and established that Rice Street is just the worst place in the world.
I know,
And
he's
he
not
wanted
going
to
into
get
that
out.
anymore.
Also,
Matters for each witness that has to sit in Rice Street while they make this decision.
He may be trying to establish sympathy, but I think
You're
what he's
establishing state of
legally trying
mind.
to do is establish motivations for testifying, and that he's allowed to do.
motivations for, you mean
For
entering.
whatever
court?
he's doing, for whatever this witness is doing.
You should
That's
know
a
what the point is,
legitimate-
love.
Would the court
Oh
indulge
my
and
God.
ask Mr. Schardt just to repeat so that I can write it down exactly what those questions are that he intends to ask and that the court is about to rule on?
Oh, you're gonna watch him say the thing word for word?
I'm going to try to do it as consistently as possible. I was kind of making them up
Off the cuff, I
off the
know.
cuff. You were aware that other people arrested on this case had not hired attorneys on by December 28, 2022. On December 28, 2022, you were aware that other people arrested on this case had not hired attorneys.
Okay,
On December 28, 2022, you were aware that some people that had not hired attorneys had not been appointed counsel and remained unrepresented,
Okay,
and you did not want to be
one of those people.
one of those people at Rice Street without an attorney.
Okay. And Ms. Love, if you want to voice what your objection is, if any, to those questions for the record, you may.
I'm getting that last contact one down. Remains unrepresented.
Tabiz, me too. I'm so
Had
heated.
not been appointed counsel and remained unrepresented.
So I have, you are aware that other people arrested on this case had not hired attorneys on December 28, 2022. And the second one is you were aware that some people who had not been appointed attorneys remained unrepresented on December 28, 2022, and you did not want to be one of those people. Did I get
Well,
it?
that was my phrasing of it. His phrasing
You did
was
not
It's crazy.
want to be
unrepresented and in Rice Street.
correct.
She shouldn't be able to micromanage his question after every time she was told to rephrase that
So,
triple
Your Honor, I
sustain.
believe that the second question, in as much as he did not want to be unrepresented and in Rice Street, is fair to establish that point. But I believe that Mr. Sledge's awareness of other people or lack thereof or speculation about whatever their status was, it would amount to speculation, number one. It would
Hang on,
amount to
wasn't
hearsay.
Mr. Sledge a defendant in this
He
case?
was.
up
He
until
was.
the
I don't know if
time?
Ms.
So that's not speculation.
I don't know if Ms. Love was here, but we
What?
had court hearings where
Okay,
unrepresented
I'm going to
people all sat
permit,
right
so
there.
is that a relevance objection or?
It is
something else?
there is a relevance objection to it. Yes, there is a relevance objection as well.
I'm going to permit all of those over objection.
Thank you.
Anything else you think we're going to need to hash out outside of the presence of the jury?
It also,
Should just
it
stop.
also, it suggests impermissibly in my mind that the plea that Mr. Sledge gave was, and I mean, this may be something that we just argue, wasn't given knowingly, voluntarily, and willingly, when Mr. Sledge has already said that he pled guilty knowingly, willingly, and voluntarily.
You've got the video in evidence where he says that. and
Right.
Yeah,
what he
knowingly,
said,
willingly,
so.
and voluntarily because he didn't want to sit in Rice Street
So
for
is
7
there-
months.
Are there any other issues we think are going to need to be taken up outside the presence of the jury while we're doing this?
Mr. Steele just sent
Cross.
over a Dropbox link and we don't know what's in it yet, so we have to review it and we don't know yet whether
All
there's
right,
something
Ms.
else.
Jill, is that your potential cross? Okay, all right.
In Your Honor,
Yes, sir.
I plan on you, I'm sorry. In Your Honor, I just handed the state a one proposed exhibit that I'll be using, DS-36. It's actually from Discovery, but I've taken out all the commentary. It's ironically something that they're seeking to admit.
Okay, well, then they should not have an.
Yeah, you would think that would be the case, but it's pictures of Kelvin Watts, Miss Entrevia Smith, and Mr. Sledge. And I'm going to ask him if he knows who those people are.
Any issue with that?
No, Your Honor.
Okay.
Not to this. I haven't seen the rest of what's
Okay,
new in the
I
Dropbox.
know, everybody, nobody's seen Mr. Steele's stuff in the context of its use. Obviously, they've seen it in Discovery, but yes, sir.
Yes, Your Honor, I do have a document.
Okay,
I have a document as well that's provided in Discovery.
Okay.
That I intend to introduce in a short statement.
all right, thank you.
And, see where we are.
Great, thank you. You want to go ahead and do that right now?
Yes, Your Honor.
All right, go ahead, Mr. Schardt.
Thank you, Your Honor. May it please the court. Good afternoon, Mr. Sledge.
Good afternoon, Mr. Shaw.
All right. We had just, last thing I asked you was about your representation. Do you recall?
Yes,
Okay, and that you had not hired Mr. Wright for trial.
no,
On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection relevance.
Just trying to educate on how it usually works. I'll move on.
Yeah.
Okay.
Okay.
On December 28th, 2022, you were aware of co-defendants on this case who had been arrested.
Yes.
And there were some of those individuals who could not afford attorneys, correct?
Right.
And you were aware that some of those individuals were in Rice Street,
Yes.
or they were in Rice Street,
Yes.
and those individuals that could not afford attorneys had not been appointed attorneys as of December 28th, 2022, correct?
Yes.
Okay. And isn't it true that you did not want to be in their position?
Yes.
Meaning you did not want to be in Rice Street without an attorney.
Yes.
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
Yes.
Okay. Do you know what coercion means?
No.
Okay. What about pressure?
Yes, I know what pressure means.
Okay. Being in, and this is your truth, I'm not asking for a legal definition, okay?
Yes.
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to plead to accept this deal?
Yes, a lot.
Okay. Being separated from your sick mother and your children.
Your Honor, I object. This line of questioning is already been, so asking me.
Your Honor, he testified for 3 days already. I've been going for 10 minutes.
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet.
No.
He wanted to go home, and now I'm asking about
Okay.
pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes.
Excuse me, December 28, 2022.
Yes.
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes. Fact,
Ask and answer, relatives go beyond.
how about facts not in evidence too?
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
Object, that assumes facts not in evidence. And it also calls for speculation.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
Yes.
Okay. All right. I want to talk to you about the plea offer. And when you need to, you can refer to it, but I want you to listen to my questions, and if you can answer without, that's fine.
Yes.
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
Yes.
Okay. And the state's plea offer was an offer for probation.
Yes.
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
Yes.
Okay. And you have to check in with a probation officer.
Yes.
In your mind, that's preferable to prison.
Yes.
That's preferable to sitting in Rice Street jail, correct?
Yes.
Okay. Probation would get you back to your family,
Yes.
get you back to your ill mother,
Yes.
and that would solve your issues as far as hiring an attorney to try the case.
Yes.
Good layout of problem and solution for each
You were
detail.
interested in a plea for probation.
Yes.
Okay. Now, as it turned out, there were factual acknowledgments that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgments that you had to initial?
No.
Okay, but at some point your attorney told you to get this probation, you're going to have to agree to factual acknowledgments.
Yes.
Okay. Let's talk about the factual acknowledgments. Do you remember the first time you saw the factual acknowledgments on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Miss Love or any other prosecutor in this case?
Objection vague as to your truth and.
You kind of defined your truth with him.
2015, vague overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Objection
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Stupid.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgments?
No.
Okay.
Great for the defense.
On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp something like that.
Okay, on the top of the paper.
Yes.
Is there letterhead that indicates whose office that paper is from?
It's a Fannie Wilson. That what you're talking about, right?
Yes.
Yes.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgments?
No.
Okay. Who presented the factual acknowledgments to you? Was it Miss Love?
Yes.
Okay. Did you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay. I'm not trying to embarrass you. You're a smart man, okay?
Right.
But you did indicate that you didn't know what the word notoriety means.
Yes.
And you've also just said you didn't know what the word coercion means.
Yes.
Okay. Could you look on that in that document with the factual acknowledgments? Should be page 3. I'm going to ask you to look at factual acknowledgement 1. On the last line, does it have the word notoriety?
Yes.
Okay. I'm going to look at factual acknowledgement 5 on the last line. Does it say notoriety?
You sound 5.
Yes.
Yes.
I'm going to ask you to look at number 16. On the third line down on 16, does that say notoriety?
Give me 1 second.
think
You said on
16
what
is,
line?
The third one down on number 16. That's page 5.
Yeah, I'm on page 5.
Okay.
Yes,
All right.
16 is
Could
one of
you
the
go to
ones
page
that
6
she nudged him to say
and
was
look at
true
the
after he was
last
saying was
word on
false.
page 6. Does it say coercion?
yes,
And those are words to this day, I guess before this trial maybe, that you never knew the meaning of.
still don't know the meaning of them.
Okay. Do you write sentences using words that you don't know the meaning of?
Objection, Your Honor, relevance.
Sustained.
Now, in preparation of your plea, whether it was on December 28th or before that, you did speak to your attorney, Mr. Wright,
Yes,
about the acknowledgments,
yes,
correct?
yes,
And you brought certain acknowledgments that are on that sheet to the attention of Mr. Wright and told him you don't agree with those.
yes,
Okay. And were you present for discussions that Mr. Wright had with Ms. Love or the state?
no,
Okay. But to your understanding, some of the acknowledgments that you did not agree with, the state refused to change, correct?
yes,
Okay. And you wanted to go home.
yes,
Did you let a disagreement with those acknowledgments stop you from getting home to your sick mother?
Objection, speculation, and.
I said, did you let?
Objection as to the form of the question, whether did he let that? Objection.
Can you rephrase your question?
Those disagreements with the acknowledgments, did you let those disagreements get in the way of you getting home to your sick mother?
no,
Objection, Your Honor.
I mean, you basically asked the same thing, the same way, you just moved the the phrasing around. I don't really know. Can you rephrase it again?
Okay. Can I break it up?
You
Okay.
can try.
You disagreed with some of the factual acknowledgments that Ms. Love presented to you, correct?
yes,
Okay. And you brought that to your attorney's attention.
yes,
And you were told that the state was not going to change those factual acknowledgments.
yes,
Okay. On December 28th, 2022, did you let your disagreement with the factual acknowledgments stop you from entering that plea?
no,
Why not?
because I wanted to go home to my sick mother.
There you go. Full circle. Closed loop.
You have, during direct testimony, when Ms. Love was asking you questions, you've stated that you disagree with several of the factual acknowledgments in this plea agreement that you
Yes.
signed, correct?
Yes,
You watched the video of your plea earlier today, correct?
yes,
Okay. Those acknowledgments on that video, who was reading those acknowledgments? Was it you or Miss Love?
Miss Love,
Okay. When you were saying yes, ma'am, do you remember that? To
yes,
pretty much every question, is that fair?
yes,
Weren't there times during that plea, during that video, where you were saying yes, ma'am, before Miss Love even asked the question?
yes,
Why were you saying yes, ma'am, if you disagreed with the factual acknowledgments?
I was just trying to get home to my sick mother.
Okay. Did your attorney tell you, or you testified that your attorney told you that you could explain those disagreements later, correct?
If I was called into the stand, yes,
Okay. And you were advised not to let those disagreements get in the way of going home, correct?
Objection, Your Honor. Objection as to attorney-client privilege, objection as to hearsay, objection.
All of them.
as
All
to
of the objections.
improper line of questioning to an improper topic.
Okay, sustained on facts not in evidence.
Okay. When you came to testify in front of this jury, you were under the impression that you would be able to explain what you disagreed with, correct?
yes,
Do you know the saying, you're between a rock and a hard place?
yes, I heard of them.
Okay. Do you consider yourself in between a rock and a hard place right now?
Yeah, yes,
Okay.
He sat back when Love objected.
The rock is that you know some of these things in this plea agreement aren't true, correct?
yes,
The hard place is you don't want to go back to prison, do you?
yes.
Yes, you do not want to go
I
back.
don't want to go back to prison.
Okay. And the problem is your plea agreement, correct?
Yes,
Let's talk about this plea agreement. In this indictment, you were charged with 2 counts, correct?
yes,
Count 1, Rico,
yes,
or conspiracy to commit Rico, I should say.
yes,
And count 30 was a gun charge, correct?
yes,
Specifically, possession of a firearm by a convicted felon.
yes,
Facing 30, 40 years.
For count 1, let's talk about that, what the plea agreement was, okay?
yes,
The agreement, if you initialed the factual acknowledgments and entered a plea, the agreement was that the state was going to recommend 15 years of probation.
yes,
And that meant that you would get out of jail immediately.
yes,
I'm going to ask you to look at Part 5 of the plea agreement, number 2, under defendant's sentencing acknowledgments.
What page is that, Mr. Schardt?
That's
5.
page 5.
Okay. And what number?
It's number 2 under section 5.
Yes, I'm looking at it.
Your agreement states that defendant, that's you, right?
Yes,
Okay. Defendant understands fully that if he violates any provision or any special condition of the plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections. And in parentheses, it says prison. Is that accurate?
yes,
Okay, so let's break that down a little bit. You're aware that a condition of your plea is to testify consistently with the factual acknowledgments you signed
yes,
that you say are not true.
yes,
And according to this agreement, if you fail to testify consistently with those acknowledgments, the state can move to revoke your probation, correct?
yes.
Do you know what revoking probation is?
Yeah, I think take it back, send you the, however, take the probation back up. Revoke it and send you to prison.
Okay, so if you have 15 years remaining on probation,
Yes,
the state can bring a motion and ask the judge to send you to prison for those 15 years instead of being on probation, correct?
yes.
Okay. Let's talk about the agreement for count 30, possession of a firearm by a convicted felon. Okay. Your lawyer told you that count,
Sustained.
you were aware that count carries a mandatory 15 years in prison,
Yes,
and that 15-year sentence needs to be consecutive to any other sentence that you have.
yes,
So it'd have to be 15 on top of the 15.
yes,
On page 1, under negotiated sentence, it says, where it says count 30,
you said page 1?
yes, page 1, sir.
Okay. Yes,
It says for count 30, that was the possession of firearm by a convicted felon, correct?
yes,
Okay. It says sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant, that's you, right,
yes,
has complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees the defendant shall be allowed to withdraw his plea on count 30, and the state shall agree to no pros count 30. That's what it says, right?
yes,
Okay, so let's talk about what your understanding of what this means. On December 28, 2022, you pled guilty to possession of a firearm by a convicted felon.
yes,
Okay. And under normal circumstances, that would be 15 years in prison consecutive.
yes,
Okay. But the state in this agreement allowed sentencing was withheld, correct?
yes,
So you weren't, even though you pled guilty to count 30, you were not given a sentence.
yes,
You were not given 15 years to serve in prison.
yes,
And sentencing was withheld until after this trial.
yes,
Okay. And your understanding is if you testify in accordance with this plea agreement, the state will dismiss that case.
yes,
Even though you've already pled guilty to it, the state will go back, let you withdraw your guilty plea, and dismiss the case.
yes,
You've been in trouble before, right?
yes.
Okay, you ever have an agreement, a situation like this in any of your other cases?
Sustained.
Is Love just pretending to write?
I'm going to ask you to look at part 5, number 4. Okay, and that's under defendant's sentencing acknowledgments. You with me?
Yes, I'm with you.
It's on page 6, right?
Yeah, 6, 7, yeah, I'm with you.
Okay. Number 4 says, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in his plea agreement, such failure or refusal nullifies. Do you know what nullifies means?
No,
Okay. It says nullifies though, right?
yes, it say that, but I don't know what it means.
Nullifies any promise made by the district attorney to no pros count 30 of this indictment. Right?
Yes,
And to your understanding, regardless of whether you know what nullifies means, if you don't testify consistently with the factual acknowledgments that the state wrote,
yes,
they will take back their promise to dismiss count 30 and you'll be sentenced.
Yes.
And you have to get 15 years in prison,
Yes.
consecutive to the probation that would be revoked.
Yes.
Can you look at number 3 under section 5? So I'm on page 5 now, going into page 6.
I'm with you.
Says, defendant understands fully that any violation or of any provision or any special condition of the plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
Yes.
Okay. All that on that video talking about he has to testify truthfully. In your mind, who gets to determine whether you testified truthfully or not?
Objection, relevance, and objection improper and vague. Who gets to determine?
He was about to answer. He knows what I'm asking.
It's a binary question whether it's true or not. But determining whether something is true is irrelevant.
It's
Rephrase your question,
Who-
please.
who gets to revoke your who moves to revoke your probation if they're not happy with what you say here today?
Miss,
Objection.
We already heard Miss. We know who you're gonna say.
Unfair characterization. What is your objection?
One, yes, that.
I said who moves.
Relevance
Gonna squeak when she sits down.
And the terms of the agreement that Mr. Sledge entered into have already been put before the jury, and the characterization that is being made at this point is improper and not relevant.
Sustained on the improper part. If you wanna try to rephrase it.
Have you, in your life, have you ever seen a defense attorney try to revoke someone's probation?
Your Honor.
Sustained.
Can you go to section 5, number 5?
I'm with you.
Okay, and that's on page 7.
Yes. 6, 7. Right.
Excuse me, you're right, 6. Thank you. Says, defendant understands fully that defendant's violation of the provision of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections
35.
/ prison. So it says, right?
Yes.
Okay. We talked about 15 plus 15. That equals 30, right?
Right.
But in number 5, it's saying you're going to serve as much as 35 years.
Yes.
And even though that's an extra 5 years, you initialed it.
Yes.
Why did you initial it?
Wow.
Because I wanted to get home to my mother.
That was a great question.
Okay.
And I ain't understand whatever the words you've been using. I don't understand the words there.
That I'm using or that are in this document?
In the document, right?
I just want some clarity.
Yes.
You testified that you have a 9th grade education. You attended Southside High School, now Maynard Jackson High School, right?
Yes.
Okay. In the video, you said 10th grade. Is it 9th or 10th, or you?
I was
Sure.
actually trying to say I completed the 9th, but I was in the 10th grade.
Okay. You ever receive any legal training?
No.
Okay. I'm going to ask you some questions, and I'm not asking what the acknowledgments say at this point, okay?
Yes.
Well, let me take that back for a second, okay?
Yeah.
Just to make sure we're on the same page.
Yes.
Okay. Let's talk about the acknowledgement. Now, number 3 on the factual acknowledgements, that's on page 3. You with me?
Yeah, I'm with you.
All right. Now, you testified that this acknowledgement is in fact false, correct?
Yes.
Okay. I'm going to read the acknowledgement with you, and then we're going to talk about the truth, okay?
Yes.
The acknowledgement says, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein defendant brandished a weapon used to drive in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, parentheses, girlfriend.
Yes.
Okay, that's what it says.
Yes.
And so you see where it says, and to support, in the first line, I'm just going to reiterate, and to support and express loyalty to YSL. It says that in there, right?
Yes.
And it says, on behalf of YSL.
Yes.
Okay. Let's talk about that. Ms. Copeland. May I approach, Shauna?
You may.
I can't get over the timing of the squeak as soon as she made an argument and then it squeaked at her when she sat down.
I'm showing you a document marked DS-36,
Yes.
okay? Do you see that there's 3 pictures in that document?
Yes.
Okay. Can you identify the 3 people in those pictures?
Me, Antonio Sledge, and Trevor Smith, and what his name, Watson or Kevin Watson, whatever.
Kelvin Watts?
Yes.
Is that also Shell Kel?
Shell Cal, yes.
You also call him Kel?
Yes.
Okay. Your Honor, at this point, I would ask to admit DS-36 into evidence.
Submitted.
Permission to publish, Your Honor.
May.
Mr. Kokomo, would you please publish?
Would have been stupid to
DS-36.
object.
Okay. Now, Mr. Sledge,
Yes.
we talked about how you're with a lady with the initials DB now, correct?
Yes.
Okay. Before DB, back in 2015, was there a young lady that you were involved with?
Yes.
Okay. And what was that young lady's name?
And Trevor Smith,
Okay. And what did you call her?
Trevor.
Treva?
Yeah, Trevor.
Treva. Okay. Do you see Treva in DS-36?
She at the top of the photo,
Okay. And do you see yourself in DS-36?
right there to the left.
Okay. And who's the other gentleman in the bottom right on DS-36?
That's Cal.
Okay. Kelvin Watts?
Yes.
Okay. Do you recall when you started, how would you describe in respectful terms your relationship with Miss Entrevia Smith?
How did I, at the time,
Yes.
it was great.
You cared about her.
Right.
would you call her your girlfriend?
Yes.
Okay. When did you start dating, we'll say, Miss Smith?
I've been knowing her since probably like, I've been dating her since probably like 2009, but as the relationship, probably like 2013.
Okay, so by 2015, you'd been in a relationship with her for at least 2 years, maybe longer.
Yes.
And you've known her for 8 years at that point.
Yes.
9 years. Okay.
Yes.
At some point, did she start dating another man?
From my understanding, yes.
Okay, and who is that other man?
Kevin Watt.
Okay. And do you know, was she dating, and I'm not trying to embarrass you, was she dating you first or Kelvin Watts first?
Me.
Okay. Do you know from your vantage point when she started dating Kelvin Watts?
I don't know at the time when she started dating.
Okay. And when you found out that she was dating Kelvin Watts, did you immediately break up with her and say, no, I don't have anything to do with you? Or did you keep having a relationship with her?
We kept conversing.
Okay. Did the fact that you and Mr. Watts were simultaneously dating Miss Smith, did that create problems between you and Mr. Watts?
Yes.
Okay. Did that lead to an internet back and forth between you and Mr. Watts?
Yes.
At some point in 2015, did you hear that Mr. Watts was looking for you?
Yes.
And was all that revolving around your rivalry over Antrevia Smith?
Yes.
You remember when the state played a video of you and Mr. Zachary with guns?
Yes.
Okay. You said it was childish, right?
Yes.
And at this point, Your Honor, I would ask for the state to publish what's 441Y. It's either 441Y or 395Y. 441 Yankee, thank you. Could you publish that?
Little strip this ass nigga. When little strip this ass.
Okay, thank you.
Little strip this ass nigga.
We ain't really going back and forth no nigga.
We don't go. You little bitch ass nigga.
I know
wanna
we
see
hate.
me? I'm everywhere. Yeah, fuck you nigga, Cal. Whoever else, nigga. Well, nigga. Nigga.
Whoa. They said I ain't really going back.
Okay, thank you. All right. Back in 2015, were you a little bit emotional about the situation?
Yes.
Okay. And in that video, that was posted on the internet, correct?
Yes.
Did you post it on the internet?
I think me or Zachary posted, one of us posted.
Okay. You intended for Mr. Watts to see the video.
Yes.
And in the video, you said you heard that Mr. Watts was looking for you, right?
Yes.
Okay. And you're in that video with guns,
Yes.
and you're in that video with Mr. Zachary,
Yes.
and that's Quindarius Zachary, right?
Yes.
Little D from Cleveland.
Yes.
Okay. And that is someone that you have known since he was little, right?
Yes.
You grew up together in the Capitol Homes neighborhood in Atlanta.
Yes.
Apartments.
Yes.
How far did you grow up from him?
How far did I grow up?
That was a horrible question. You guys were both living in the same apartment complex, right?
Yes.
Now you're older than him,
Yes.
and he was a little boy at that time, right?
Yes.
Okay. Would you see him every day?
No, I wouldn't see him every day.
How often would you see him?
When I used to walk past his door to get to the basketball court, he'll be on the porch.
Okay. Are you particularly close with him? Or
At
were you back in
At that time,
Yes.
no.
In 2015, you weren't.
Oh, 2015, we were very close.
Okay. And in that video, did you ever hear anyone say YSL?
No,
Did you ever hear anyone say gang?
no,
Did you hear anyone say on behalf of?
no,
Okay.
On
Did anyone
behalf
tell
of.
you to make that video?
no,
That was your decision.
yes,
And you made that video because you were mad at Kelvin Watts because he was running his mouth,
yes,
because y'all were dating the same woman.
yes,
Okay. So let's go back to factual acknowledgement 3, which deals with this video. It says, while associated with YSL and to support and express loyalty to YSL, did anything about making that video and talking junk to Kelvin Watts, did any of that video have to do anything with supporting and expressing loyalty to YSL?
no,
Okay. And then later on in factual acknowledgement 3, it says, and wherein on behalf of YSL. Was there anything about that video that was done on behalf of YSL?
no,
Thank you. Okay. Let's talk about factual acknowledgement 5. It says, okay, let me back up. Factual acknowledgement 4, let's look at that, and that's on page 3. You with me?
yes,
All right. It says, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant, that's you, right?
yes,
And fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video, referenced in part 3 of this section, targeting family members of a rival gang. Okay?
yes,
All right. And then on number 5 of the factual acknowledgments, it says, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4. Okay? Above, on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. See where it says that?
yes.
Okay. And I'm just reading that. I'm not saying it's true.
You okay?
Okay, let's talk about that case. And that was 15 SC 138994.
Yes,
You were charged in that case, correct?
yes,
Mr. Demekion Garlington was charged in that case, correct?
yes,
And Mr. Quindarius Zachary was charged in that case, correct?
yes,
No one else was charged in that case.
no,
And that night, April 28th, 2015, I believe you testified you were at the Club Crucial,
yes,
and Demekion Garlington was at Club Crucial.
yes,
And you didn't go together, right?
no,
But you both happened to be there.
yes,
And you're friends with Demekion Garlington, or you were at that time.
yes,
Okay. And at some point, well, let me ask you one other thing. There were some young ladies at the club that you knew as well, correct?
yes,
Alexis Bryant was at the club, right?
yes,
And a young lady named Summer Good was at the club.
yes,
And Summer Good is the girlfriend of Quindarius Zachary.
yes,
Okay. Quindarius Zachary was not at the club,
no,
okay, but his girlfriend was.
yes,
Okay. And you indicated that Demekion Garlington was jumped by certain individuals.
yes,
Okay. You don't Did you observe the fight?
Not from the beginning, no.
Okay. On that date, did you know, while you were at the club, did you know who was jumping Demekion Garlington?
No.
Okay. Was this a major fight?
It was
Let me ask a better question, because
Okay.
that was vague.
okay.
Was this the type of fight where people were punching and kicking Demekion Garlington?
Yes.
Okay, and there are a lot of people at Club Crucial, right?
Yes.
A lot of other people you knew.
Yes.
Okay. Demekion, you said you left the club without Demekion Garlington.
Yes.
Okay. But then you received a call from Demekion Garlington.
Yes.
And the reality is Demekion didn't have a car.
Yes.
Okay. You had a car.
Yes.
Right. So Demekion asked you to pick him up.
Yeah, he asked me to come back and pick him up. Yes.
Okay. Demekion was upset, correct?
Yes.
Was Demekion drinking that night?
I can't tell you if he was drinking that night. He probably wasn't even in the club that long. So I don't know if he was drinking or
Do you
not.
know if he was using drugs, popping pills, anything like that night?
Probably before he got there, but I didn't see him popping the pills.
Okay, were you drinking that night?
Yeah, I was drunk.
You said you were drunk?
Yeah, I was drunk. Yeah, drunk. Yeah.
Okay. So Demekion is upset after getting jumped in the club, and he calls you to come pick him up. And you're drunk, and you think he might have been popping pills and don't know what else, right?
Yes.
Demekion had been publicly humiliated, right?
Yes.
When you guys are driving from the club, Summer Good and Alexis Bryant were following y'all's car, correct?
Yes.
They were leaving the club at the same time.
Yes.
And again, that Summer Good being Quindarius Zachary's girlfriend.
Yes.
Okay. And to your understanding, Summer Good was scared
Yes.
because people were following her car.
Objection, Judge, calls for speculation.
Sustained.
Okay. Well, it was your car and Summer's car. Was there another car following behind y'all?
Yes.
Okay. And when Darius Zachary, who wasn't in the club, was called about the situation, correct?
Objection, calls for speculation. Or in hearsay.
Well, you went to pick up,
Sustained.
okay, you went to pick up Quindarius Zachary, right?
Yes.
Okay. And the purpose of you picking up Quindarius Zachary was to take him to the house where Summer Good was,
Yes.
to protect her.
Yes.
Your Honor, objection, and answer that part of speculation.
It's gonna be-
And what?
She knows the discovery. It's going to be completely obvious.
It's background hearsay.
Well, I mean, it's happened at this point. Let's kind of get to whatever it is that you're trying to get to here.
Summer Good was at a house, at Alexis Bryant's house on Landrum Drive, correct?
Yes.
And you and Demekion Garlington, this is after the fight, picked up Quindarius Zachary and drove to that house on Landrum Drive
Yes.
where Summer Good was,
Yes.
okay? And when you all arrived at that house, you saw someone shooting at that house,
Yes.
shooting at the house that Summer Good and Alexis Bryant were in.
Yes.
You were driving the car, right?
Yes.
Not the car that was shooting. You saw a car shooting and you're driving in a car pulling up.
Yes.
You chased those people off that were shooting at the house, correct?
Yes.
Okay. at some point, and I think your testimony is that you don't know who they were, but one of the other individuals in the car, your car, determined who was shooting at the house that Summer Good was in, correct?
Yes.
And it was determined that you were to drive them to the house where those people stayed at.
Could you repeat that? Cause I didn't understand.
I asked in a bad way. You're in the car, and it was determined, someone, not you, but someone felt they knew who was shooting at the house with Summer and Alexis, right?
Yes.
Okay. And then you ended up driving to a house.
I don't think I went to another house after that, Mr. Shaw. I'm not for sure.
Well, let me back up. In your testimony, you said your testimony was you drove Quindarius Zachary and Demekion Garlington to a house, right?
Yeah,
And they had guns,
yes,
and they got out and did whatever they did to that house.
yes,
Okay. That wasn't the house that Summer Good and Alexis Bryant were in on Landrum.
no,
Okay, so after you saw that house, the first house where Alexis Bryant and Summer Good were being shot at, you drove to another house where Demekion and Quindarius did whatever they did. Right?
yes,
Okay. And you pled guilty to that.
yes.
You don't know who jumped Demekion Garlington.
No,
Okay. You drove to the first house on Landrum where Summer Good was because Quindarius Zachary wanted to protect his girlfriend.
yes,
And once you saw people shooting at the house, Demekion Garlington and Quindarius Zachary wanted revenge, right?
yes,
Quindarius Zachary wanted to go back at the people that were shooting at his girlfriend.
yes,
And Demekion Garlington wanted to go back at the people who he felt jumped him in the club.
yes,
Okay? That was personal revenge, correct?
yes,
In retrospect, you're 43 years old,
yes,
okay? You know Quindarius Zachary since he was this big.
yes,
You know Demekion Garlington, I believe you knew him since he was a baby too, right?
yes,
Okay, in retrospect, you were the older person in the situation, correct?
yes,
You should have known better than to drive them anywhere, right?
yes,
Okay, but you did.
yes,
Okay, but the bottom line, and you pled guilty,
yes,
and you served your sentence.
yes,
The bottom line is Jeffrey Williams didn't instruct you to go drive to any houses that night.
no, Jeff wouldn't know nothing about it.
Okay.
Objection as to speculation about what someone else knew.
Sustained.
Ask that portion be stricken from the record.
Okay, you don't know what Jeffrey Williams knew on any given night, but he didn't order you to go to any house.
No, no,
Okay. And no one was out the window shooting guns, yelling, YSL, YSL.
Objection, compound question.
Overruled.
no,
On behalf of.
The reality,
Overruled.
no,
Okay, law and crime. Why
The
did I do that when
reality-
love is over there?
Mr. Sledge, is what happened on April 28, 2015 was done on behalf of Demekion Garlington, who got jumped in the club.
yes,
Was done on behalf of Quindarius Zachary, whose girlfriend was getting shot at.
Yes.
It was not done on behalf of YSL.
No.
It was not done to increase the notoriety, reputation, or fear of YSL, was it?
No.
Okay. The state asked you about, I'm on page 5, Mr. Sledge. Number 14 and 15. Okay. And I'm gonna read those in a second, but I just want to ask you some questions. Okay. We already established it. Did you grow up, Mr. Sledge?
Yes.
We'll get to that in a second.
Okay.
I want you to listen to my question. Okay.
Yes.
Thank you. You grew up. We've established that you lived in Capitol Homes. Did you grow up in Capitol Homes?
Yes.
Okay. And Capitol Homes, does that still exist, or has it been torn down by now?
They tore down, but they call something else now. Capitol Gateway or something like
Little
that.
Gateway.
Yeah.
Okay. Could you help me understand what area of town, what street is Capitol Homes on?
Memorial Drive.
Okay, it's on Memorial Drive, maybe 5 minutes from this courthouse, right?
Yes.
Okay. They made it nicer now,
Yes.
but back then it was rough neighborhood, right?
Yes.
Okay. And then how long did you live at Capitol Homes? Till what age?
I don't remember exact how old I was, but whatever year they got tore down.
Were you a teenager or
Yeah, I was a teenager.
like,
I probably was grown.
so if you were a teenager, we're talking about 18, 19, not 13.
Yeah.
Okay.
Yeah.
All right. And then eventually you ended up living off of Boulevard, correct?
Yes.
Okay, did you go straight from Capitol Homes
To Boulevard.
to Boulevard? And when we say Boulevard, we're talking like the Bedford Pines.
Yeah, Bedford Pine Apartments.
Okay, those are right by the intersection of Boulevard and like North Avenue, right?
Yes.
Okay, great. East side of Atlanta.
Yes.
Okay, both these places, Capitol Homes and Boulevard, are, well, you tell me, how long do you think it would take to drive to Cleveland Avenue?
I can't give you an exact how long, but if my mind regular, probably about 15. Probably 15 minutes from Capitol Home, probably about 19 from Boulevard, 20 somewhere in there.
Okay. Bottom line, it's not the same neighborhood,
No,
miles apart.
miles apart.
Okay. Have you ever lived off of Cleveland Avenue?
Stay off of Cleveland Avenue.
Or on Cleveland Avenue, or stayed off of Cleveland Avenue?
Yes.
When was that?
I want to say it was probably like 2008, 2009, somewhere in that era.
Okay. And for how long? I'm not asking for exact address. You live off of in the Boulevard area now, right?
Yes.
Okay. So how long did you stay on Cleveland Avenue?
Not long. Well, my kids stayed over there, but I actually moved to Boulevard.
Okay.
But my kids and their mother still stayed over there, so I used to go over there.
Okay, so you used to go over there.
Yes.
And I'm asking you, okay, correct me if I'm wrong. Did you ever formerly live over there?
No.
Okay. Now, I hate to ask you this, but you've been a drug dealer before in your life, right?
Yes.
Okay, you have a history of, your criminal record reflects that, correct?
Yes.
Okay, you've been arrested for selling drugs downtown
Yes.
Atlanta.
Yes.
Okay, you've sold drugs in the past. We're talking about the past, off of Boulevard.
Yes.
Okay, you've sold drugs around many areas of Atlanta, correct?
Yes.
You talked about hanging out in these gas stations. And you said, your testimony, as I recall it, was that sometimes you would hang out in the gas station with your own personal bag.
Yes.
And if people wanted a little bit of off your personal bag, you would sell it to them.
Yes.
Okay. And you would hang out with Christian McMiller and Darius Ford.
Yes.
Okay. Personal bag, we're talking about bag of marijuana?
Yes.
Okay. And we're talking about if someone, for me, for instance, asked you, hey, can I buy some of that marijuana off of you? We're talking about $5, $10 type stuff, right?
Yeah.
Okay. Petty.
Petty. Yeah, some petty.
Okay. Do a lot of people sell drugs out of gas stations in your experience? Has foot traffic, right?
Objection, relevance as to whether or not a lot of people.
Sustained.
Have you sold drugs in gas stations before?
Yes.
Okay, you sold drugs in gas stations downtown, right?
Yes.
Objection, relevance as to whether it's sold drugs at other gas.
It's relevant, Your Honor.
Not territory.
Oh,
Argument was
Yes, you
territory.
sold drugs at gas stations off of Boulevard before, right?
Yes.
Okay. And your testimony is that you would occasionally hang out at some gas stations on Cleveland Avenue with your personal bag of marijuana,
Yes.
with your friends Big and Mac Mac.
Yes.
Okay. Would you be there 24/7?
No.
Okay. How many times would you say total that you hung out at these gas stations? Is it more than a dozen?
Yes.
More than 2 dozen?
Yes, probably more. Yeah. I pull up and just kick it and then leave.
Okay, when you say you would pull up and kick it and then leave, is it fair to say that you were not part of some complex drug distribution network in these gas stations?
No.
Okay, so when you would just kick it and leave, we're talking about you staying around for how many minutes?
Sometime an hour less.
Okay. All right. And you say you thought, I want to get this right. You thought maybe more than a couple dozen, more than 25
Yeah.
times total.
Yeah.
Sometimes stay for like an hour.
Yes.
You'd also hang out at the park,
Yes.
hang out at other stores.
Yes.
That's where the mother of at least one of your children lived.
Yes.
Okay. That area, not the gas station.
Yes, that area.
All right. And from your observation, and I know you don't want to speak on the dead, so I'm going to keep it brief. Your two friends would sell drugs at those gas stations.
Yes.
They'd sell drugs other places too, right?
Yes.
Okay. Tell me about the time that you and Christian McMiller and Darius Ford pulled out AK-47s and chased everyone out of the parking lot to protect drug turf.
Never.
Okay. You just observed two people selling weed at a gas station before.
Yes.
Okay, let's go back to your factual acknowledgments that you signed on December 28, 2022. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Okay, now it is true that in your mind, Darius Ford and Christian McMiller were YSL associates in your mind.
Yes.
And they would sell drugs at these two gas stations, 151 Cleveland Avenue and 221 Cleveland Avenue, and a bunch of other places, correct?
Yes.
Okay, but you haven't seen anyone do anything that would lead you to believe that they did not allow other gangs to operate in those gas stations, did you?
No,
No violence,
no,
no attacks.
no.
The factual acknowledgement that the video about Shell Kel had
Yes,
something to do with YSL, that was incorrect.
yes,
The factual acknowledgement that the shootings on April 28th, 2015 were done on behalf of YSL, that was incorrect.
yes,
The factual acknowledgements that YSL or YSL associates do not allow other gangs to operate at these two gas stations, those were incorrect.
yes,
These money that you would make selling little $5, $10 bags, whatever, of marijuana, would you run to Jeffrey Williams and give him those $5 bills, $10 bills?
never,
Okay, would you run to Shannon Stillwell and give him the $5 and $10 bills?
never.
Mr. Sledge. I'm going to ask you to go to page 6 or 7 again. Okay, let me ask you, before you sign these documents on December 28th, you moved for bond on this case, correct?
Yes,
You moved for bond on October 13th, 2022, correct?
yes,
And the state opposed your bond, right?
yes,
They said that you were a danger to the community.
yes,
They said you were a threat,
yes,
and you were denied bond.
yes.
He was a threat, but then you needed him out. Why? You needed
That
him to
kept you
plea.
away from
Why?
your family.
Yes,
On the bottom of page 6, it says, the last sentence, I freely, knowingly, and voluntarily entered into this agreement without force, threat, or coercion. And we already said you didn't know what coercion meant.
yes,
Let's just say pressure.
yes,
That's not true, is it? You were pressured.
yes, I was pressured.
In fact, you were pressured into signing a document that claims that you're entering the agreement without pressure.
Yes,
We talked about that bond hearing before December 28th, where the state called you dangerous, too dangerous to release.
Objection, Your Honor, one fact's not in evidence, two improper,
He was
and
there.
three irrelevant.
Cry.
He was there. Did they call you? It's not for the truth of the matter asserted, it's for the state's stance.
Objection relevance. The state
It's
stands
very relevant.
regarding a bond matter for this witness has.
Oh, that
no
squeak is
relevance
coming.
or bearing on the guilt or innocence of either of the defendants here.
No, it doesn't, but I don't think that's what he's offering it for.
I'm
I'll
not.
permit it.
They told you, they said to the judge that you were too dangerous to let go, right?
yes,
Okay. When you initialed these acknowledgments that they wrote, they gave you probation, right?
yes,
And then something came up.
And Your
Because-
Honor, I'm sorry, I know that the objection needs to be at the same time, but as I thought about it, that was hearsay as well. What the state told him about.
She already made the ruling.
dangerousness or whatever.
Squeak again.
I'm not saying it's dangerous.
Literally, the question was, did the state say that you were too dangerous to let go? That's hearsay. There is no, that's hearsay.
It's not for the truth of the matter asserted.
Overruled.
Again, they said, not saying you're dangerous. They said you were too dangerous to let
Objection,
go.
I already asked and answered.
Well, I'm trying to recap because I keep getting interrupted.
Well, she's entitled to interrupt you if she thinks she's got a legitimate evidentiary objection.
Okay. After you initialed these documents next to the statements that they wrote, they gave you probation on count 1, right?
Yes,
Objection asked and answered.
Okay, sustained.
And something came up in court because you pled guilty to count 30, but weren't being sentenced. You had to be given a bond on that in order to be released.
yes,
And all of a sudden, on December 28th, after you initialed these statements, the state recommended a signature bond. Isn't that correct?
yes,
A signature bond means you get released and you don't even have to pay any bond at all, right?
yes,
Have you ever been able to figure out what made you so dangerous before December 28th?
Sustained.
I have no further questions. Thank you.
All right.
Beautiful.
Charity,
Holy
I need a
moly,
break
beautiful.
Before we move on to the next cross. Okay, let's take a 10-minute or so break.
Holy moly, that was beautiful. Shout out to Max Schardt. Oh my god. Hold on. Max Schardt owning with the squeak every time she tried to argue. That was so good. And oh my god, you guys, the squeaks, you guys reacting and now waiting for the squeak is like so great. It is so great. It is so great. And for anyone that didn't catch what the point of that, they denied your bond. He hinted at it a bit in the beginning, but he was too dangerous to be
All right.
bonded out.
We'll recess.
But with a plea, when they needed him to dot the line, oh, you're suddenly safe enough to put back out into society after we just denied your bond and wanted to hold you. Then we let you plea because you agreed and you said you would come testify to these things that we never showed you before. You didn't see this plea agreement until the day you signed it. They never asked you about these things that they made you acknowledge. Beautiful, beautiful, beautiful cross. And nice to see Schardt start that off.